how cool is this?
Breaking news from the State House. One of the big bills in front of the Senate.
Members of the Senate are focusing on gun rights.
So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court.
So another unanimous ruling from the Supreme Court.
Pretty based move here by the state of Missouri saying, no, we are not going to fund federal violations of the Second Amendment.
The U.S. Supreme Court has just issued a major ruling.
The Supreme Court just handed down an 8-1 decision that's sending genuine shockwaves through the gun rights community. And what makes this ruling even more stunning is that conservative justices voted decisively against a state actively trying to protect Second Amendment freedoms. The legal strategy that was specifically designed to shield gun owners from federal overreach just backfired so catastrophically that it might have inadvertently handed significantly more power to Washington rather than limiting it. This wasn't just another routine court ruling with predictable outcomes. This represents something far more consequential for the balance of power between states and the federal government. Missouri didn't just pass a law protecting gun rights within their borders. They created what became a financial death trap for their own police officers and law enforcement officials. The Second Amendment Preservation Act imposed a devastating $50,000 fine on any law enforcement officer who cooperated with federal agents on gun-related investigations. And here's what nobody talks about when discussing this law's impact. This wasn't a one-time penalty applied once, regardless of how many cases an officer worked on. Every single case counted separately under the law's language, which meant a county sheriff working on just 4 federal investigations in a single year could face $200,000 in cumulative personal fines, more than triple the average annual salary of a Missouri law enforcement officer. Within the first 6 months of the law's activation, 47 separate lawsuits were filed by Missouri citizens against their own police departments, and county budgets started hemorrhaging money at an alarming and unsustainable rate.
Major Supreme Court ruling.
This is a case dealing with a state's Second Amendment Preservation Act, also known as the SAPA law.
The Supreme Court will be taking up a gun rights case.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law.
On its opening day of the new term, the U.S. Supreme Court rejected Missouri's bid to revive its law aimed at declaring various federal gun restrictions unconstitutional.
What made this situation particularly devastating for individual officers was that they couldn't obtain liability insurance to cover these penalties. Insurance companies systematically classified them as intentional violations of state law rather than accidental errors, which meant every single penny of those fines came directly from the officers' personal finances, potentially bankrupting officers simply for doing their jobs. Between 2015 and 2021, over 560 cities and counties across America declared themselves immigration sanctuaries, and they did something remarkable that conservatives watched with both frustration and fascination. They successfully blocked federal ICE agents from accessing local jails, using municipal resources, or obtaining information from government databases. And the Supreme Court consistently upheld their right to do exactly that under constitutional principles. San Francisco stopped honoring ICE detainer requests entirely in 2015, and despite repeated threats from the Department of Justice, they faced 0 meaningful legal consequences. New York City implemented similar policies and went even further, passing laws explicitly prohibiting city employees from even asking about immigration status, effectively creating an information blackout that severely crippled federal enforcement operations. Conservative attorneys watched this happen year after year, lawsuit after lawsuit, and they saw sanctuary cities win repeatedly using a constitutional principle called the anti-commandeering doctrine.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act for the purpose of making a state a two-way sanctuary state.
This is a case that's been bounced around back and forth throughout the court system.
Last week, representatives from police departments in Branson, Rolla, and others testified against it.
The logic seemed ironclad. If the Supreme Court definitively said states couldn't be forced to help ICE enforce federal immigration law, then states logically couldn't be forced to help the ATF enforce federal gun law either. The constitutional principle should apply equally regardless of the subject matter, but Missouri's legislators made one catastrophic mistake in how they drafted their law, an error that sanctuary cities had carefully and deliberately avoided, and that single mistake destroyed their entire legal strategy. Clarence Thomas has now cast a solitary dissent or unusual vote 73 times during his Supreme Court tenure, more than any other sitting justice by a factor of 3, and his position in the Missouri case reveals something extraordinary about how far he's willing to go to protect state sovereignty. Thomas didn't even write a full dissent this time. He simply noted he would have granted Missouri's stay request, which in Supreme Court language means he thought the other 8 justices missed something fundamentally important about constitutional structure. His judicial philosophy embraces originalism so strictly that he's voted to overturn precedents that have stood for over a century, including cases involving the Commerce Clause that have formed the backbone of federal regulatory power since the New Deal era. Legal historians compare his approach to Justice John Marshall Harlan's solo dissent in Plessy versus Ferguson, the 1896 case that upheld racial segregation, because Harlan stood completely alone and was vindicated 58 years later when Bruen versus Board of Education overturned that decision. Thomas's vote in the Missouri case wasn't actually about protecting gun rights at all. It was about something far more fundamental to constitutional structure that would have reshaped the entire relationship between federal and state governments, and the consequences of his vision being adopted would have been absolutely staggering for federal power.
Decided that the Missouri Second Amendment Preservation Act, or the SAPA law, is invalid because a state law like this is invalidated by federal law because of the Supremacy Clause.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Saying setting a higher threshold in an emergency could mean life or death.
The civil remedy here, or the lawsuits here that are going to be filed, are not going to be filed by the state of Missouri.
It's a case that legal experts will be watching closely.
On June 23, 2022, the Supreme Court issued the Bruin decision and established a revolutionary new test that threw out decades of established Second Amendment law, requiring any gun regulation to be consistent with America's historical tradition of firearm regulation from the founding era. Within just 18 months, over 450 federal and state gun laws faced serious court challenges using this new standard, and the success rate for gun rights advocates skyrocketed from 23% to 67%, a complete reversal of outcomes that genuinely stunned legal experts. Federal judges suddenly had to research musket regulations from the 1700s, dueling laws from the 1800s, and frontier gun policies from the Old West to determine if modern restrictions were constitutional. Even more striking, gun rights organizations collectively poured $89 million into lawsuits using the Bruin standard, and they won far more often than they lost, creating a wave of Second Amendment expansion that continues accelerating. The Bruin decision was systematically dismantling gun control laws across America through the federal court system. If gun rights advocates were already winning this war through traditional litigation, why would Missouri risk everything on an extreme state law that directly challenged federal authority?
The right to keep and bear arms shall not be infringed.
It triggers something in me that something has to be done.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
State said we are going to take away all the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents.
The Bureau of Alcohol, Tobacco, Firearms, and Explosives conducted 37,872 compliance inspections of gun dealers in 2023 alone, a staggering 340% increase from the 11,122 inspections conducted in 2016. And these inspections resulted in the revocation of 122 federal firearms licenses, effectively destroying gun stores for what owners claim were minor paperwork errors rather than actual criminal activity. A gun dealer in Oklahoma lost his license after ATF inspectors found discrepancies in 3 transaction records out of 14,000 total transactions. Errors the owner claimed were simple transcription mistakes that posed absolutely no public safety risk. The ATF has wielded regulatory authority to reclassify items without any congressional approval, declaring bump stocks to be machine guns in 2018 and forcing over 520,000 owners to either destroy their legally purchased devices or face federal felony charges carrying up to 10 years in prison. Most controversially, despite explicit legal prohibitions against creating a federal firearms registry, the ATF maintains a massive database containing over 920 million firearms transaction records at their National Tracing Center in West Virginia. Missouri legislators looked at these numbers, saw federal agents with power to redefine legal products as felonies overnight, and they panicked. But their solution didn't just fail legally. It walked straight into a constitutional trap that has existed since before the Civil War.
Give us transparency on how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
This case could reshape how far states can restrict your right to carry it.
Recently, the Supreme Court issued an order denying a stay that would have protected the state of Missouri's Second Amendment Preservation Act.
Article 6, Clause 2 of the Constitution contains just 68 words known as the Supremacy Clause, establishing that federal law represents the supreme law of the land and overrides conflicting state laws. But Missouri's case becomes fascinating because they weren't actually trying to override federal law directly. They were using the anti-commandeering doctrine that the Supreme Court has repeatedly affirmed. States cannot be forced to enforce federal law, a principle the court established in Prince versus United States in 1997 when they ruled the federal government couldn't require state law enforcement to conduct Brady Act background checks on gun purchases. But Missouri's attorneys made one fatal error in their language choice that transformed everything about their case. The Second Amendment Preservation Act declared federal gun laws invalid within Missouri's borders. That single word, invalid, converted their law from constitutional non-cooperation into unconstitutional nullification, the same doctrine southern states attempted before the Civil War when they claimed authority to void federal laws within their territories. 8 justices saw the nullification language and refused to even consider Missouri's arguments about anti-commandeering or state sovereignty, because the moment a state declares federal law invalid, they're not refusing to help enforce it, they're claiming authority to override it entirely. And that crosses a constitutional line established through the bloodiest conflict in American history. The Supreme Court just set clear boundaries for how far states can push back against federal power, but multiple states are already rewriting their laws using the exact constitutional language that might actually survive judicial review. What happens next will determine whether gun rights expand or contract in your state, and whether the federal system can survive this escalating power struggle. That's it for today, folks. See you in the next video.